Good evening. We begin tonight with breaking news. We have obtained what is expected to be a central piece of the government's case against Donald Trump. The actual audio recording of the former president talking as if he's showing a highly classified document on U.S. war plans against Iran with people not cleared to even know it exists, let alone what's in it. In a moment, only on CNN, you will hear what jurors will hear one day. The recording was made 2 summers ago, July 2021, at the former president's club in Bedminster, New Jersey. You will clearly hear the former president as he is speaking to several people. According to the special counsel's indictment, they include a writer working on Mark Meadows' memoir, the publisher, and 2 of Trump's staff members. The president was aware he was being recorded. This is the first time it is being played publicly.
All right, people, welcome back to Dr. John Podcast. The Supreme Court ruled 6-3 that Trump exceeded his authority by imposing sweeping tariffs under a 1977 emergency law, IEEPA, since that law never explicitly authorized tariffs. However, the ruling did not freeze his entire presidency.
These are bad, sick people.
That was your coup, against you.
Well, it started right at the beginning.
Like when Millie's talking about, you were going to try to do a coup. No, they were trying to do that before you even were sworn in.
That's right.
Trying to overthrow your election.
Well, with Millie, let me see that. I'll show you an example. He said that I wanted to attack Iran. Isn't it amazing? I have a big pile of papers. This thing just came up. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him.
Wow.
We looked at some. This was him. This wasn't done by me. This was him. All sorts of stuff. It's pages long. Look. Wait a minute. Let's see here.
Yeah.
I just found, isn't that amazing? This totally wins my case, Mm-hmm. Except it is like highly confidential, secret. This is secret information. But look at this. You attack, and
Hillary would print that out all the time,
she'd send it. No, she'd send it to Anthony Weiner, the pervert.
Please print.
By the way, isn't that incredible? Though?
Yeah.
I was just saying because we were talking about it, and he said he wanted to attack Iran and what? These are the papers. This was done by the military, given to me. I think we can probably, right?
I don't know. We'll have to see. Yeah, we'll have to try to
Declassify.
figure out
See, as president, I could have declassified it. Now I can't, but this is classified.
Now we have a problem.
Isn't that interesting?
Yeah.
It's so cool. I mean, it's so. We here and I have. And you probably almost didn't believe me, but now you believe me.
No, I believe
it's incredible, right?
No,
hey, bring some Cokes in, please.
Trump simply announced new tariffs under a different law within hours. So yes, a real and significant court loss. Now here is why those 3 words matter beyond the tariff context. Apply them to the Iran war, a war Trump launched without a declaration, without an authorization for use of military force.
Well, joining us now, CNN anchor and chief correspondent Caitlin Collins, also our senior legal affairs correspondent Paula Reed. Caitlin, first of all, what do you make? This is the first time we are hearing this audio. We'd seen a transcript. There's more in this audio than we actually had seen, I think, in the transcript. What stands out to you?
Yeah, there is more in this. And this is a 2-minute clip of what a recording that we're told is over an hour long. But this is, of course, the part that is at the center of Jack Smith's investigation. And we knew about this. CNN first reported that this existed and that Jack Smith's prosecution had it in their hands. But to hear it, I think really just drives home.
Without any congressional vote approving military action against a sovereign nation, without anything that could plausibly be described as clear congressional authorization for a massive offensive military campaign, the Supreme Court just established.
And it undercuts everything that Trump has been saying. I mean, even as of a few days ago, he was saying there was no document per se. But you can hear him very clearly in there referencing something in his hands.
You can hear him shuffling through papers.
And he's not just saying, here's this document. He very clearly appears to be showing it to them.
He
of
says,
course,
look.
Only the people in the room could know that, but you can hear in that why this is so critical to Jack Smith's case, because it's Trump acknowledging, I have this document, It is secret. It is classified. I cannot.
In a binding 6-3 majority opinion that dramatic exercises of claimed executive power require clear congressional authorization. The Iran war has no clear congressional authorization. The parallel is not subtle, and the legal community has not missed it. The Brennan Center said the war was unconstitutional. The ACLU said Trump breached the Constitution by invading Iran without Congress.
I was just saying, because we were talking about it, and he said he wanted to attack Iran and what? These are the
You did.
papers.
It's pretty
This was done by the military, given to me.
That wasn't in the indictment. That part of it, I think, was not in the indictment. Why do you think that is?
It's unclear. What he's talking about there, that he, for people who aren't watching it super closely, is Chairman Mark Milley, the Joint Chiefs of Staff. And he's basically saying, this is proof that he wanted to attack Iran, not me. We should note that the document that is in question here, we are told it was predated Milley. It wasn't actually something that he produced. But it speaks to something that we've heard, the former national security officials in Trump's orbit talk about, which is this is not just any kind of information, any kind of document. This is the nation's secrets, which don't just change on a daily basis. You don't just come up with a new attack plan for Iran, that he is just brandishing proudly to random people in the room. These are random autobiographers who are working for Mark Meadows that are in the room. They don't have security clearances that he's showing this to. And I think this audio changed a lot about the way that Trump's legal team viewed this case. They told me, and Paula and I and our other colleague Kayla, we've been covering this for months, we had heard they weren't worried about this investigation, that they had this argument that, he just took what he had with him, it wasn't nefarious. He's trying to use that now, saying it's just golf clippings. You can see there, he knows exactly what he has. He knows that it's not declassified. It's his own words.
And it's why he is showing it to them, and to bolster his own case, to show himself, to brag, essentially.
And there's reporting on how the DOJ and the FBI, they had kind of struggled as they were investigating this. They knew that there was classified information that had not been returned, but they obviously had questions about Trump's intent. This was before they knew that, there are surveillance videos of him moving boxes around before his attorneys come to search. And I think this also speaks to his intent here.
I also wonder at the end where he says, bring us some cokes. I wonder if Nada, his body man, is in the room because he is now also facing charges.
And that was Walt Nada's primary job in the White House. He was his valet. He did things like go and fetch Diet Cokes and Cokes for Trump. And of course, he's the one getting arraigned tomorrow. Yeah.
Paula, with that in mind, I want to play what Trump said to Fox last week in this interview.
Politico's legal analysis concluded there is no legal argument for the war. Georgetown's International Affairs Journal called it an impeachable abuse of office. Reed Brody, a prosecutor who has actually put heads of state on trial, applied the crime of aggression framework from Nuremberg to the 2026 war. The constitutional law consensus has been unanimous from the beginning. The Iran war requires clear congressional authorization that it does not have.
There was no document. That was a massive amount of papers and everything else talking about Iran and other things. And it may have been held up or may not, but that was not a document. I didn't have a document per se. There was nothing to declassify. These were newspaper stories, magazine stories, and articles.
So he's downplaying the papers he's holding as articles and magazine stories. Clearly, that does not seem to be the case when you hear this audio and he says these are the papers. And he said, look, this just popped up.
Yeah, and it's significant because these are the papers. That specific quote, that was not included in the transcript that the special counsel included in its indictment. And now it has taken on more significance because he has sort of altered his defense here to say, no, I didn't have a document per se. There were no documents. Now, we reached out to the special counsel's office to ask if this was an intentional omission or a mistake. Special counsel's office declined to comment, but Anders said, your team's been working all day to try to get our own transcript. I helped them a little bit, and it appeared it took about a dozen iterations before everyone agreed on exactly what they were hearing. So it is most likely just a mistake, and it's unclear at this point if the special counsel will make an amendment to the indictment to include that line.
It is an interesting idea, though, if it was an intentional omission in order to see how the president would react. I mean, maybe that's like thinking chess too much in advance, or maybe I'm overthinking this.
The Supreme Court tariff ruling did not directly adjudicate the war, but it established a legal standard in a binding majority opinion that the constitutional law community is now citing as additional support for the war powers argument. This is how legal architecture accumulates. not through single decisive rulings, through the building of a consistent doctrinal framework across multiple cases and contexts.
They had the opportunity, look, to go on background with us, to go on the record, say, hey, we made a mistake. There, as you can hear there are a lot of different layers to the audio, and at this point, it's just unclear if this was a mistake, if they didn't hear it, if it was a typo or an intentional omission. But it is likely to come up in the course of this case, because again, this is a really significant substantive line now.
And Paula, beyond, in terms of the other people in the room, do we know exactly who they are beyond being incredibly sycophantic?
Yeah, no, you make a great point. Among the people in the room, Liz Harrington, one of the people who works with the former president on communications, Margot Martin, one of his longtime aides, and two people working on an autobiography for former White House Chief of Staff Mark Meadows. And it is really surprising when you hear this recording, these voices that even the special counsel has labeled as staffer, egging him on. Laughing, again, like you said, being sycophantic. It sort of encouraged him throughout this feedback that he was getting from the room. And in hindsight, you have to ask whether his staffers were really serving his best interest, given their responses throughout this exchange. Even at one point, one of the staffers acknowledged, well, now we have a problem, but they're still sort of laughing, even nervously.
The major questions doctrine established in West Virginia versus EPA. Extended and applied in the Supreme Court tariff ruling, now available to be applied in any future legal challenge to the Iran war's authorization or to any of the emergency power claims Trump has made in conducting it. Each application adds to the framework. Each framework addition makes the next application more supported and more likely to succeed. And the accumulation does not stop at the domestic legal framework. On the international legal record, you have Iran's arrest warrant for Trump over the Soleimani strike, sitting in the legal system, deferred during his presidency, becoming more actionable as the immunity clock runs. You have Iraq's domestic warrant through its Supreme Judicial Council. You have Reed Brody's crime of aggression analysis applied to the 2026 war. You have the Belgian government formally calling the campaign a violation of international law. You have the command responsibility framework implications of dismantling the civilian harm mitigation unit documented by the Pentagon whistleblower. All of it building simultaneously with the domestic legal record. Layer on the congressional near misses. The House vote on a bipartisan withdrawal resolution. 7 votes away from forcing Trump to withdraw or seek authorization. The Senate war powers vote. 6 votes away from a Senate majority for constraints on his Iran war authority. The impeachment resolution tabled, but with 79 members voting to proceed despite leadership's blocking operation. The resignation demands from members of his own party. The Not One Dime More protest movement on Capitol Hill. All of it building political pressure that the legal record compounds. The Supreme Court tariff defeat feeds the broader pattern that every major legal outlet identified immediately. This is a president who claims emergency powers he does not have, who acts without the clear congressional authorization the Constitution requires, whose expansive view of executive authority keeps running into courts that say the authority is not as expansive as claimed. The pattern is now documented across tariffs, immigration enforcement, agency purges, and the Iran war authorization question. The court just added one more documented instance to the pattern. Trump insists everything is legal, everything is under control, the war is nearing completion, the economy is the strongest ever, the emergency powers are valid, the authorization question is settled in his favor. All of this insisting is happening as the legal record builds, case by case, ruling by ruling, resignation by resignation, ally rebuke by ally rebuke, into the most comprehensive accountability architecture constructed around an American president in modern history. The collapse is not a single moment, it is a process. And the Supreme Court tariff ruling is the most recent and most institutionally significant piece of it. Let me build the full accumulated legal picture, because the Supreme Court ruling only makes sense as the crushing loss the headline describes when it is understood in the context of everything that has been building. Start with the doctrinal significance of the tariff ruling and why Roberts' clear congressional authorization language is the specific phrase that matters for the Iran war. The major questions doctrine, the legal framework the court applied in striking down the tariff scheme, has been developing across a series of Supreme Court decisions over the last several years. West Virginia versus EPA established a core principle in the environmental context. The court held that when an agency claims authority to make decisions of vast economic and political significance, it must point to clear congressional authorization for that specific authority, rather than relying on broad inferences from general statutory statutory language. The tariff ruling extends this principle to presidential emergency powers. The claimed authority to impose tariffs of any amount on any goods against any country for any duration based solely on the president's emergency declaration is a decision of vast economic and political significance. Congress has not clearly authorized this specific claimed power. The emergency statute's general language does not provide the clear authorization that the major questions doctrine requires for claims of this magnitude. Therefore, the claim fails. Now apply the framework to the Iran war authorization question. The Commander-in-Chief clause, the constitutional text Trump is using to justify launching a massive offensive war without congressional approval, is a general grant of military authority. It does not clearly authorize launching a massive offensive military campaign against a sovereign nation without any congressional vote. Launching such a war is unquestionably a decision of vast political significance, one of the most significant decisions a government can make. The constitutional provision being claimed, Commander-in-Chief, does not provide the clear authorization that decisions of this magnitude require under the framework. The court has now applied this framework in multiple contexts. The parallel is not airtight. The court has historically treated war powers differently from domestic regulatory or economic powers, applying more deference to the executive in the foreign military domain. The political question doctrine gives the judiciary significant cover to avoid directly adjudicating war authorization disputes. A federal court challenge to the Iran war's authorization faces justiciability obstacles before reaching the merits. But the doctrinal parallel exists, and the legal community is using it. The clear congressional authorization standard that Roberts applied to emergency tariff powers is the same standard that the constitutional law consensus has been applying to the Iran war authorization question from the beginning. The Supreme Court ruling does not decide the war powers question, but it adds institutional weight to the doctrinal framework that would decide it. A future federal court considering a war powers challenge to the Iran conflict, whether brought by members of Congress, by affected parties, or through some other vehicle, would be operating in a legal environment where the Supreme Court has recently and explicitly reaffirmed the clear congressional authorization requirement for major executive power claims. That environment makes the constitutional case against the war stronger, not weaker, even without a direct Supreme Court ruling on war powers. Now let me lay out the accumulated record that the Supreme Court ruling sits on top of. Because the crushing loss the headline describes is not just the tariff ruling in isolation. It is the tariff ruling as the most recent and most institutionally significant layer of a legal architecture that has been building throughout this entire series, the constitutional law consensus. The Brennan Center calling the strikes unconstitutional and warning that congressional inaction emboldens further overreach. The ACLU's national security lawyers saying Trump breached the Constitution by invading Iran without Congress. Politico's major analysis concluding there is no legal argument for the war. Georgetown's International Affairs Journal, calling it an impeachable abuse of office. This consensus represents the legal community's professional judgment applied to the constitutional text and the documented facts of the war's launch. It is not binding authority, but it is the intellectual framework within which judges, legislators, and accountability mechanisms operate. The war powers resolution violation. The 60-day clock that started when forces were introduced into hostilities. The deadline that passed without Trump seeking or obtaining congressional authorization. The continuing operations that represent an ongoing documented violation of federal statute. The war powers resolution is law. Violating it is violating law. And the violation is documented, dated, and ongoing, adding to the legal record with every additional day of operations without authorization. The congressional near misses. The House vote, 7 votes from a force withdrawal resolution. The Senate war powers vote, 6 votes from a Senate majority for constraints. The 79 House members who voted against tabling the impeachment resolution, an on-record congressional assessment that impeachment proceedings were warranted. These votes are not rulings. They are political acts. but they document the institutional judgment of a significant congressional minority across both chambers, with bipartisan participation, that Trump's war authority claims are constitutionally untenable. The international legal record, Iran's arrest warrant over the Soleimani strike, sitting in the legal system with an Interpol red notice request pending. Iraq's domestic warrant confirmed by the Supreme Judicial Council. Reed Brody's crime of aggression analysis from a prosecutor who has actually put heads of state on trial, applying the Nuremberg Supreme International Crime Framework to the 2026 war. Belgium's formal government determination that the campaign violates international law. The command responsibility implications of the Pentagon whistleblower's account of the Civilian Harm Mitigation Unit's dismantlement. The Trump Organization criminal conviction and civil fraud findings. The documented pattern of financial conduct that provides context for the administration's institutional credibility on any question involving accurate reporting of costs or compliance with oversight requirements. The Supreme Court tariff ruling 6-3, Roberts writing. Clear congressional authorization required for dramatic exercises of claimed emergency power. The most powerful court in the country, applying the most relevant doctrinal standard to the most analogous claimed authority and finding the claimed authority invalid. The legal and political environment Trump is operating in. They reinforce each other in specific ways. The constitutional law consensus provides the analytical framework. The War Powers Resolution violation provides the specific statutory breach. The congressional near misses provide the political validation of the legal argument. The international legal record provides the accountability instruments that become active when the immunity clock expires. The financial fraud history provides the credibility context, and the Supreme Court tariff ruling provides the binding presidential support for the core doctrinal principle. No single layer is sufficient on its own to produce the accountability outcome: impeachment and removal, forced withdrawal, criminal prosecution, or international legal process. But all six operating simultaneously create a legal and political environment in which the accountability probability compounds. The immunity clock that is running toward the end of Trump's term is running in an environment where the legal record against his second-term conduct is more comprehensive, more multi-layered, and more institutionally supported than any comparable record against any previous American president. The pattern that major legal outlets identified after the tariff ruling is now undeniable. This is a president who routinely claims powers he does not have, who acts without the clear congressional authorization the Constitution requires, whose expansive view of executive authority keeps running into courts that say, no. That pattern is now documented across tariffs, immigration enforcement, agency restructuring, and the Iran war authorization question. Each documentation adds to the pattern. Each pattern addition makes the next accountability mechanism easier to activate and harder to dismiss. Trump's insistence that everything is legal, that the war is authorized, that the emergency powers are valid, that the court's ruling is limited to tariffs and has no implications for his other claimed authorities. This insistence is happening against a legal record that is saying the opposite across 6 simultaneous layers. The insistence does not change the record. The record is building regardless of the insistence. The collapse the headline describes is the collision between the insistence and the record, between what Trump claims about his authority and what the accumulated legal architecture, constitutional consensus, statutory violation, congressional near misses, international instruments, financial fraud history, and now binding Supreme Court precedent says about that authority. The court said no, 6-3. Roberts writing on the emergency powers theory that has been the foundation of Trump's entire second-term governing strategy. That no, delivered by the court Trump built, written by a Chief Justice appointed by a Republican president, joined by at least 3 justices from the conservative supermajority that Trump believed was safely in his corner, is now sitting on top of every other legal defeat we have documented, compounding them, reinforcing them, building the legal record that accountability mechanisms will draw on for years. Let me break down what this actually means for Trump and for the country. The Supreme Court did not just strike down tariffs. It struck down a theory of executive power, the theory that a president can declare an emergency and then do anything. That theory is now legally dead. Roberts wrote that clear congressional authorization is required for dramatic exercises of claimed executive power. That means every time Trump wants to do something dramatic, something vast in economic or political significance, he has to go to Congress. He cannot do do it alone. He cannot declare an emergency and bypass the legislative branch. The Constitution does not allow it. The court just said so. Now apply that to the Iran war. The war is a dramatic exercise of claimed executive power. It is perhaps the most dramatic exercise of claimed executive power possible, short of using nuclear weapons. It involves the lives of American service members. It involves the sovereignty of a foreign nation. It involves billions of dollars in military spending. It involves the potential for regional escalation and global conflict. If the Supreme Court's standard applies, and the legal consensus says it does, then the Iran war requires clear congressional authorization. It does not have it. Therefore, under the court's reasoning, the war is illegal. The court did not say that directly. The political question doctrine gives the judiciary cover to avoid war powers disputes. But the reasoning is there. The framework is there. And every lawyer, every judge, every member of Congress who reads that opinion sees the implication. The war powers challenge that has been building in the legal community now has Supreme Court precedent to cite. Not precedent on war powers directly, but precedent on the underlying principle that dramatic executive action requires clear congressional authorization. That principle now has the weight of the highest court in the land behind it. The international legal community is also watching. Iran's arrest warrant, Iraq's warrant, the crime of aggression analysis, Belgium's determination, all of these are moving forward in an environment where the domestic legal record is also building against Trump. The immunity clock is running. When Trump leaves office, when he is no longer protected by presidential immunity, these international instruments become actionable. He could face arrest if he travels to certain countries. He could face prosecution in international tribunals. The legal walls are closing in from every direction, and the congressional near misses tell us that the political walls are closing in too. 7 votes in the House, 6 votes in the Senate. That is not a landslide, but it is closer than any previous president has come to having his war powers constrained by Congress. The 79 members who voted against tabling the impeachment resolution. That is nearly 80 members of Congress who went on record saying that impeachment proceedings were warranted. That is not nothing. That is a significant minority. And as the legal record builds, as the Supreme Court adds its weight to the constitutional case against Trump's power claims, those numbers are likely to grow. The resignations from inside the administration tell the same story. People who worked for Trump, who believed in his agenda, who were loyal to him, are leaving. They are resigning because they cannot defend the indefensible. They are resigning because they do not want to be part of a legal record that is going to be scrutinized for years. They are resigning because they see the collapse coming and they want to get off the ship before it sinks. Trump's response to all of this has been the same as always: denial, attacks, insults. He calls the courts a disgrace. He calls the rule of law a disgrace. He calls the Constitution a disgrace. He insists that he has the power to do whatever he wants. He insists that the war is authorized. He insists that the tariffs were legal. He insists that the emergency powers are valid, but the record says otherwise. The court says otherwise. The Constitution says otherwise. And that is the collapse. Not a single moment of dramatic defeat, not a gavel falling and a president being led away in handcuffs, but the slow, steady, relentless accumulation of legal architecture that says no. The Supreme Court said no. The appeals court said no. The district court said no. The international community said no. Congress came within a handful of votes of saying no. Members of his own administration said no by resigning. The legal record is now so comprehensive, so multi-layered, so institutionally supported that no amount of denial can undo it. The immunity clock is running. The legal instruments are waiting. The accountability mechanisms are poised. And when Trump leaves office, when the protections of the presidency fall away, all of this accumulated legal architecture is going to come down on him at once. The tariffs ruling, the war powers violation, the international warrants, the congressional record, the financial fraud findings, all of it, simultaneously, from every direction. That is the endgame. That is the collapse. And it is happening right now, in real time, as the legal record builds day by day, ruling by ruling, resignation by resignation. The Supreme Court added its voice to the chorus, the most powerful legal voice in the country. 6-3, Roberts writing. Clear congressional authorization required. Trump does not have it. He never did. And now the court has said so. The collapse is not coming. It is here. It has been here. It is just becoming visible to everyone who was not paying attention. The legal architecture that no amount of Truth Social posts can undo. The record that no amount of congratulations to everyone can erase. The court said no. The record says it has been saying no for months. And the collapse is the sound of that no finally being heard.